This case is important because of its reasoning, but it's even more notable due to the very strong opinions expressed by the judges about the behaviour of the defendant, the Church of England. In 1939, landowners in a small English village called Billsthorpe leased a small plot of land to the rector of the local church for use as a garden for a nominal rate of 10 shillings per year. Rent was paid until 1942, but after that time the owners of the land did not seek further payment. The land, including the small plot, changed ownership several times, but each owner was a staunch supporter of the church and did not seek payment of the nominal rent. Sometime later, however, the church subleased the land to a third party who used it as a parking lot, even resurfacing it. The church decided to sell land to that tenant, including the small plot which had been leased to them. The owners objected, but the church claimed they were now the true owners of the land. Their claim was that they had adverse possession of the land and that any action to eject them must fail due to the limitation period which had commenced upon their final rent payment. The court reluctantly found that this argument was good at law. Lord Justice Russell said, "The principle clearly accepted was that once the period covered by the last payment of rent expired, the tenant ceased to be regarded by the Limitation Acts as the tenant, and so they could eventually obtain adverse possession." The majority of the judges therefore found that there was adverse possession, but they did not wish to give that judgment. Lord Justice Davies said, "At the end of the hearing, the court indicated its strong views on the merits of the case and reserved its judgment in order that the matter should be further considered by the church authorities, in the hope that wiser, more generous and more Christian counsels should prevail, and that the defendant should withdraw from the position hitherto taken up." Wisdom did not prevail, and the church was perfectly happy to screw over the generosity of its own congregation. From this case we learn that where a tenant remains in possession at the expiry of their lease, the period for adverse possession runs from the date of the final payment of rent.